Churchill and Associates. Churchill and Associates is a property casualty firm, and Bill has a specialty in risk management for companies, especially EPLI, E&O insurance, and directors and officers insurance, along with cyber liability. Bill and I chatted about EPLI, and he knew we had a webinar a few weeks ago on the DFEH and EEOC litigation that occurs when you have discrimination charges. And Bill volunteered to do a little webinar about EPLI. So having said that, I'm going to turn it over to Bill. Now everybody, I believe we're in discussion mode, so if you can take your phones or put you on mute just while Bill talks so we don't have any background noises. All right, go ahead, Bill.
Good morning, everybody. Thank you so much for joining us, and I look forward to this. I hope everyone can hear me well. Let's just dive right into the presentation. Barry, thank you for the introduction. The first page, or actually page 2, is the webinar disclaimer. We certainly want to make sure that we keep the lawyers happy, so I put this in. Probably the most important thing to know is these policies, employment practices liability policies, all are standalone contracts. If a claim comes in, it will be interpreted against the actual contract wording and not based on what I'm interpreting here. So please understand that what I'm trying to give is a 50,000-foot view, and we can get into the details. If you have questions or would like to learn more about a particular policy, my contact information is at the end of this presentation. Oh gosh, my slides are now hidden for participants, Barry.
Yeah, I just saw that, so let me find out why that's occurring. I've never had that happen before.
I feel like I'm rearranging the chairs on the Titanic right now with the audio.
Hold on a second. That's weird. Hold on.
Okay.
That has never happened to us before. One second, everyone. Okay. Now I'm going to try. I want to upload and I want to put another slide in and see if that works.
Okay. All right. Now I see it.
You got it?
I do. Yes.
Okay. All right. Go ahead then.
So, what I would like to cover today are really 3 basic topics. Why do companies need employment practices liability? It really is becoming a type of insurance that, particularly in the state of California, you absolutely have to need because the lawsuits and the complaints filed are so frequent and severe. Second, what can companies do even before they buy employment practices liability that might help them manage the risks associated with having employees and the exposures for EPLI? And then finally, talk a little bit about the policies themselves. The Equal Employment Opportunity Commission is a federal agency. This agency has been put together to enforce a number of different laws, including Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, ADEA, the American with Disabilities Act, the ADA, the Fair Labor Standards Act, and the Equal Pay Act. It's also an investigator and considered part of the federal law enforcement agencies, and investigates to determine whether there is any reasonable cause to believe a discrimination has occurred in a particular event. It is overwhelmed, absolutely overwhelmed with the number of complaints compared to the number of lawyers that they have to do the investigations. So much so that if you look at the next slide, you start to get a feel over the course of the last 10 years, from 2006 through the last year reported, 2016. In 2016 alone, there were 91,503 claims filed with the complaints filed with the EEOC. This actually averages just about 44 claims per working hour, using a 40-hour work week in 52 weeks, or 10.5 complaints per hour during the course of a year. The worst years, of course, were 2010, 11, and 12. And why? Because we were in the heart of the Great Recession. People were losing their jobs, companies were laying off individuals, and so they were filing complaints to try and do whatever they could, either to save the job or to get whatever they could out of the company that had laid them off. What are they complaining? The largest number of complaints are for retaliation on all types of statutes. Why? Well, because whenever somebody files a complaint for discrimination, age discrimination, sex discrimination, whatever the case may be, they almost always file a complaint for retaliation. Disabilities are obviously a large number of claims, and when you think about the Americans with Disabilities Act, that can include such things as alcoholism, drug addiction, as well as other forms of disabilities. Race is a very, very big number of complaints, representing in 2016 over 32,300. I'm going to go down to the next. So the EEOC is our federal government. The California Department of Fair Employment and Housing, the DFEH, is the state equivalent. The DFEH, I know that last month Barry and the group did a really good webinar talking about complaints with the DFEH, what to do. The DFEH is the California agency charged with the protection of residents from employment, housing, and public accommodation discrimination. It can also include hate violence. One of the interesting things that I read recently was the number of hate organizations, given some of the events around the country, that are domiciled here in the state of California, and I was shocked to see the very number of them. The DFEH has a director who's appointed by the governor and maintains 5 offices and 5 educational clinics. It's considered part of the California Business Consumer Services and Housing Agency. In 2016, there were 23,510 complaints filed with the DFEH. One of the things that happened early this year that I believe Barry covered last month was the DFEH and the EEOC have linked up. So if you file a complaint with the DFEH, it automatically is filed with the EEOC. Vice versa happens as well. I often tell clients that if somebody files a complaint with the EEOC alone and tries to pursue it on a federal basis as an individual, you're almost better off because the EEOC kind of caps the losses for an individual at $250,000. When you get into the DFEH in California, it can run into millions of dollars because there is no cap on it. Like the EEOC, discrimination are a huge number of complaints, and this discrimination representing 17,388 of the 23,510 complaints filed with the DFEH in 2016. 17,041 are investigations of possibility of private suit. And what they're always looking for, whether it's with the EEOC or the DFEH, is a right to sue letter. They got 12,242. Why didn't they get all of them? Because like the EEOC, the DFEH is overwhelmed with complaints. But as I mentioned earlier, there is no cap. 1,036 cases settled in 2016, and they had a monetary value of $11,600,000. That's a huge number for our employers to have to absorb. These complaints, again, disability, retaliation was the largest group, but disability for mental or physical. Race was again a discrimination complaint. And you can see these complaints somewhat track with the EEOC. The penalties that the DFEH can levy against individuals and companies are kind of a wide variety. There's certainly actual damages for injury or losses, including back pay, future lost wages, and reinstatement wherever it's appropriate. Compensatory damages, which can include pain, suffering, humiliation, embarrassment, emotional distress, mental anguish, and punitive damages. One of the interesting things is punitive damages frequently occur in the state of California. They are not insurable with one exception, if they are vicarious in nature. So if a company is sued and an individual is sued, and let's say a hospital associated with that company is sued, and the hospital is levied against punitive damages, they can go against the company as well for the punitive damages. And if it's a vicarious reason, just association with, you can get insurance for that. Attorney's fees and costs, we certainly get them for defense. There are a lot of contracts that have what are called prevailing party clauses within them. Prevailing party clauses are generally not insurable, but a lot of these cases are taken on a contingency. Therefore, when a case is settled or damages are levied, a percentage of those will go to the plaintiff's attorneys. Those will be covered, but if you have a prevailing party clause, we can get insurance separately to cover that, which is a great negotiating tool when trying to resolve conflict. Training for employees, supervisors on Fair Employment and Housing Act, and internal grievances. You have to pay for expert witnesses. You have to pay fines, which for a hate crime or violence can be $25,000 per. And the DFH can bring a civil action directly in the court on behalf of organizations and individuals. A couple of facts. A representative study showed 446 closed claims were small to medium-sized corporations with fewer than 500 employees. 19% of those were employment charges and resulted in defense and settlement costs averaging $125,000. Small companies are not immune to these claims. More importantly, they are really disruptive for the organization. They're a distraction for management, they're a distraction for individuals, and if they take, on average, 275 days to resolve, that's a lot of attention away from running the organization and trying to do the right thing for the rest of the employees who are there. 19% of the matters resulted in a defense and settlement, effectively 1/5 of them. If you go into the others, why would they pursue them? Well, they go away for a settlement before they get to trial. And the reason they often fight the others is so that they can get the others into a settlement before they get to trial. These things are going to cost money almost without fail. The average retention in the state of California is $35,000. That is largely because the state of California is worse than every other state when it comes to these particular types of claims. Employment practices law tends to favor the employees in almost every occasion in the state of California. We also live in the most litigious country in the world. California is the most litigious state, and I often say that everything south of the 118 is the most litigious area of the most litigious state of the most litigious country. If you don't have the coverage, on average, this would run you about $90,000 of extra costs in the absence of having employment practices. A lot of them don't end up in court. Like I said earlier, they just settle, but still the damages can be pretty substantial. But the median judgment is about $200,000. 25% of the cases represent over $500,000. There's some myths. And one of the ones I hear almost every time I'm talking to a prospect or a client, my company, they're like family to me. They will never sue, and nobody ever discriminates. I often say it's wonderful to have an organization that you treat like family, but almost every family has a weird uncle or a reprobate child out there. And if somebody out there is doing something and you don't even know about it until later, or a person leaves, decides they just want to go and get another job, and some lawyer speaks to them, they often come back and file a discrimination. And some of the individuals in smaller companies who've been around for a long time still like to think that business is done the way it was done back in the 70s or the early 80s, not the way it's done today. And there's a lot more controls and restrictions and regulations and things you cannot say or do. So that weird uncle can cause you some problems. My business is small. I don't think that really, I pointed that out. Small businesses are not immune to these. In fact, a great number of the requests that I get for this coverage come to me after they've been hit by a lawsuit. And small businesses can't necessarily float the cash to lay this off. If it only costs a small amount of money to buy the insurance, but you can lay it off by buying that insurance and not have to worry about $90,000 of uninsured costs or $200,000, why wouldn't you do that? The last thing is my company will absolutely prevail in trial. Maybe. But when you put a plaintiff and the organization in front of a jury of their peers, a lot of times these juries really make decisions that may not necessarily consider the laws because they're complicated laws, but may consider just sympathy or irritation with their own employers. So you don't necessarily, when you get to trial, you're not guaranteed to win. In fact, a lot of times the carriers will strongly encourage a settlement before it goes to trial because they don't want to roll the dice. What can a company do? Insurance is a great backstop. If you're doing great risk management prior to it, I promise you it will not keep you out of court. It will not keep you from getting a DFEH complaint or an EEOC complaint filed against you. But what it will do is it will give you a paper defense in the event that you are sued or there is a complaint. And when you can show the documentation, you can do a lot of evidence, particularly during the complaint investigation. It's amazing how the number of these things go away quickly. So what are some of those risk management techniques? I often encourage everybody to have a good lawyer, whether on retainer or know who they are, who can help you with difficult matters, whether it's laying off a group of people, a termination, some kind of a complaint situation that may have bubbled up, even reviewing the employee handbook. These are the lawyers who are the ones who know the laws and are charged to keep up with those laws. So you absolutely have to make sure that you use the counsel that is available to you. Secondly, document, document, document. If you document files every time you do something and you document well, in the event of a claim, when you're going through discovery and the pre-motions, you can show evidence that you've done everything according to the law and what you're supposed to do. But you also have to be smart in your documentation. Many years ago when I was with a Chubb group of insurance companies, we were back in New Jersey and we were talking to a particular employment lawyer who told us a story that absolutely to this day resonates with me. The company was starting one of these Jewel Mart type stores that have a department with stereos and a department with jewelry and a department with electronics and all sorts of departments. And they were getting close to the opening date, so they were actively out hiring salespeople. This one lady had interviewed, did not get the job, and filed a suit based on discrimination for religion. She was Jewish. The company and the owners and the management really all had sterling reputations, and they had charged the department heads to be involved in hiring the individuals. And each and every individual who was interviewed had a file. So they pulled the lady's file with the defense counsel, and he opened it up, fortunately before they got into the motions and demands for discovery. And one of the first things he noticed is written on it was "no Jew." And he looked at the interviewer, he goes, "What's this?" And he goes, "Oh, she told me she didn't want to work in the jewelry department." The lawyer closed the files, looked at the senior management, and said, "Let's just settle this claim and move on." You've got to document, you've got to be clear in your documentation, and you've got to make sure that what you say and write is not going to cause more problems later. Know the laws. There are a lot of laws, and particularly here in the state of California, the laws change a lot. For example, in the state of California, and to some degree, I'm hearing about it on a federal basis, you can't ask anymore, starting January 1st, if an individual applicant has ever been convicted of a felony or a crime. You can find out after the fact, and I'm not sure how it's going to affect background checks. But you can't necessarily not offer the job because they have been, and you can't ask if they have been, even on the application or during the interview process. I can see what they're trying to do, which is protect those who've been convicted of crimes and have served their time and want to get back into the working world. But I can also see a lot of problems, hiring a teacher who's been a convicted sex offender. There's a lot of problems. The minimum wage laws are changing on a federal basis and on a state basis. And they become so complicated that in the city and the county of Los Angeles, various cities have different minimum wages. So if you have employees who are driving or doing work in one city and then going to another city, you have to pay according to whatever place they are working at whatever time. That can be a nightmare. Wage and hour, and particularly breaks and lunches, are wildly difficult, and they are a very frequent type of claim that employment practices policies are occasionally covering. We'll get into that, and are a complicated series of laws. For example, a few years ago, we had a client who was a truck hauler of toxic and hazardous waste. And the federal laws, environmental laws, specifically say that when you leave and you're hauling hazardous waste, you cannot leave that truck unattended until you have delivered it and no longer have the waste. Federal law. Our client was sued by a state plaintiff or California law for the wage and hour, saying you failed to give the adequate breaks, 15 minutes every 2.5 hours and a half hour after 5 hours for lunch, and you have to, therefore you have to pay it. We all thought, wow, federal law will supersede state law, this should be a no-brainer. It didn't go down that way. In fact, what they're effectively forcing the company to do is have two drivers on every particular situation, so that one is there to be at the location or at the truck if the other needs to take a bathroom break. Having an employee handbook is very, very important. Not only do you want to update it periodically, and I always encourage everybody to have either an outside HR professional or some outside counsel take a look at least once every 2 years to make sure that you're compliant with all the laws. But I also encourage every time you have a new employee, you have them sign off that they received it and they read it. That way they can't come back and say, well, I never read it, I didn't know. Well, gee, there it is. You actually said that you did. Training. There's certainly training that is required for any number of industries and any number of reasons, including employment-related issues. For example, management and supervisory employees have to have sexual harassment training at least once every 2 years. And there's a lot of companies out there who provide online training, and at the end of the training or end of sections of the training, you have to take a test and you have to pass 75% or whatever it is in order to get the certificate that you need. But it's a way of recording that every person has taken that, and that gives you, again, a paper defense in the event of a lawsuit. Finally, the EEOC has an outreach and education service available at no cost for businesses, associations, and nonprofits. They will come in and speak at conferences or seminars based on availability. This can provide a lot of great documentation, a lot of great knowledge, and frankly is something that I would use in the event of a lawsuit later. So let's talk about the policies. I want to start with the very common denominator. All EPLI policies differ from all other EPLI policies. There's certain common threads throughout many of them, but the wording is absolutely imperative that you pay attention to or have an insurance expert pay attention to for you. For example, some exclusions have what is called an absolute preamble. The wording is something along the lines of based upon, arising out of, attributable to, directly or indirectly involving, and then it goes on to whatever they're excluding. Others use the word for. They're still excluding whatever that issue is, but if they use the word for, they're going to say, we're not going to cover that issue. If they use that absolute based upon arising out of preamble, and you've got that particular pleading or allegation somewhere buried in the pleadings, the carrier, if they were really trying to be aggressive, could come back and deny all of the rest of the claim based on that particular exclusion. So you got to pay attention to what the wording is. The underwriting appetites absolutely vary from one carrier to the next. For example, one carrier won't write any EPLI insurance in Ventura, Los Angeles, and Orange County. Why? Because their results are 4 times worse than anywhere else in the United States in those 3 counties. Reinsurance varies. A lot of reinsurers will dictate what the terms and conditions and what the carrier can and cannot cover, and they will prohibit certain types of claims or certain types of industry segments so that they can't cover those. And they do this because their results have been bad. Because if you look back in the 2010, 11, and 12, where we had over 93,000 complaints, a lot of those wound up in litigation. A lot of those wound up in losses that were covered by insurance policies and reinsured out to the reinsurers. Once you get into their dollars, they start wanting to try and shore up their damages. The fact is, during 2010, 11, 12, the combined ratio, which is losses and loss allocated expenses for employment practices, was 135 on a national basis, which means for every dollar they took in, the carriers paid $1.35 out in losses. In the state of California, that exceeded 1.85. So it was an unprofitable. The reinsurers wanted to try and control the risks. You have to look, as I said, understand what they are and are not covering, and also what the underwriters are willing to and not willing to cover. Almost all EPLI policies are written on a claims-made policy form, as opposed to an occurrence. Retroactive dates, which are kind of prior acts exclusion dates, will deny the existence of the company prior to that. So I always try and make sure there are no retroactive dates. At the very least, in an organization, after about 6 years, you're pretty much outside of most of the statute of limitations anyway. A lot of these go away after 3 years. So it starts to become moot, and I use that argument. But nonetheless, I try and make sure we don't have a retro date. What a claims made says is, regardless when the wrongful act took place that gives rise to the claim, as long as the claim is made during the policy period for an otherwise covered issue or event, it will be covered, subject to the terms of the policy. This is the mirror image of occurrence, which says, regardless when the claim is made, as long as the wrongful act occurred during the policy period for an otherwise covered event, it will be covered subject to the terms and conditions of the policy. So carriers put these on the EPLI policies on claims made, so they have a better idea at the end of the accident and policy year whether they've made money, or even at the calendar year, whether they've made money on this. Doesn't mean that it's an absolute guarantee. There were no claims at the end of the policy year, woohoo, we win. It means that they have a better idea, they've contained the losses for that particular year. Even within claims made, there's different types of triggers, claims made triggers. Claims made means the claim is made during the policy year. Claims first made means the claim is first made during the policy year. How does that differ? Well, the first thing is you have to figure out what the policy reads is a claims made. Is it when you as the insured first learn of the event, like an EEOC or a DFEH complaint, or receive a demand letter, or is it when you put the carrier on notice? So paying attention to that is very important. The last one is a double trigger of coverage, and that's the most onerous of the three. That is claims made and reported. In order for it to be covered, the claim has to be made against the insured and reported to the carrier during the same policy period. Most policies that are claims made and reported contracts have a little bit of a tail end grace period that allows you to report anything that was made against you during the prior policy period. But if you go beyond that, there's ample case law that will allow the carriers to walk away entirely. So what are they covering under EPLI? A lot of different unfair employment practices allegations, wrongful termination, constructive termination, where an individual feels that the environment at the job has become so toxic that they just can't stay on the job and they have to quit. Well, they could say, well, they quit. Yeah, you made it so difficult, they're going to allege, that they couldn't stay on any longer. Harassment, including sexual harassment. Probably now built into that is some kind of workplace bullying. Discrimination based on federal, state, or local laws that can include race, creed, religion, gender, sex, national origin, age, disabilities, even now sexual orientation, genetic, sexual identification. For those of you who've gone into various restaurants, you'll see those sexual orientation bathrooms. That's a change in the law that people are now starting to have to deal with. Federal government basically under Title VII has 7 different protected classes. The state of California has 11 protected classes. The county of San Francisco, for all businesses domiciled in that county or any business that does business in that county. So if you fly up to meet with a client in San Francisco County, there are 21 protected classes. I think of this, I often think of the old charts when my mom would take me to a butcher store as a kid that had the cow up on the wall behind the counter, and it would show you through dotted lines where's the steak, where's the rump roast, where's the loin, and how they would kind of butcher a cow. I can't figure out 21 ways to carve up a person that they're not already in some other protected class. Everybody is in some level of a protected class. It also will cover things like retaliation. If you think back to the EEOC and DFEH complaints, how many there were. Failure to hire, the case I said of the Jewel Mart type store in New Jersey, or even failure to promote or failure to provide tenure. And that last one is really for educational institutions. It also provides coverage for third-party employment practices. What is that? That is an allegation of sexual harassment or discrimination brought by a non-employee against the insured. This can be vendors, clients, customers, business invitees. the UPS person, the mail person, whatever the case may be. We have to be careful because a number of organizations often find themselves hit with a third-party EPLI claim without thinking they've done anything wrong and that they're doing the right thing for their employees. These all really took off back in the 90s when Denny's had a number of different suits brought against them in the South for failing to serve African Americans or putting them in less desirable parts of the restaurant at late nights. And shortly after they settled all these cases, one, Denny's became Denny's Diner. And the second thing is I would go into a Denny's with my family, and at the bottom of it there was an EEOC statement of we will not discriminate based on race, creed, religion, sex, national origin, et cetera, et cetera. So that is a particularly hot employment law topic. Defense costs are for the most part, part of the limits and not in addition. There are a few carriers who will offer defense outside the limits, generally equivalent to whatever the limits you were buying. So if you buy $1 million policy, you can get $1 million of additional defense cost limits for the EPLI. What am I saying when they're part of? Every dollar spent on defense costs reduces the remaining aggregate by an equal amount. They're mostly duty to defend policies, either outright duty to defend or they have an option for the client to trigger a duty to defend. That means the carrier has a right and duty to defend the claim, regardless whether there's any merit to that claim. They still have to provide a defense. It's good to have these because that eliminates what is called allocation. Allocation is where a carrier will apportion out that part of a case that is not otherwise covered. It might not be a covered individual. It might not be a covered insured. It might not be a covered allegation. In the past, they would allocate out as much as they could, but when you have a duty to defend because of a number of other case law, the laws basically say if you're defending part of it, you're going to defend all of it. It does, however, duty to defend gives the right to the carrier, not to you as the insured, to choose the defense counsel. Most of them have a number of law firms on panel that they will reach out to and assign the case to them. The carriers understand that these are experienced. They probably negotiated very good rates. Instead of paying $700 an hour to a partner and $400 to an associate, they'll pay $250 across the board. But what the law firm gives up in rates on a billable per hour, they're making up for it with a lot of work. So duty to defend is a very important aspect of this. A lot of them are pay on behalf of contracts. So once you as the insured satisfy the retention or the deductible, the carrier will pay on your behalf of till the end. And then they all have definitions, exclusions, and insuring clauses. The policy giveth, the policy taketh away. And they take it away through the insuring clauses and definitions and exclusions. Who is covered? Obviously the insured organization and any subsidiary, which under the definition of all these policies is an organization or any entity that is more than 50% owned. They may give some coverage to joint ventures or minority-owned subsidiaries, but for it to automatically be covered, it has to be more than 50% owned. The other group are the employees. A lot of distinction or variations between policies occurs in the definition of employees. Almost all of them will cover anybody who is paid by the insured and has a right to direct what they do for their jobs. This includes part-time employees, seasonal employees, temporary employees, interns, volunteers, committee members, management, supervisors, employees, committee members, Some of them will give you coverage for leased employees or independent contractors. When they start doing that, some policies will then say, but only if you provide indemnification for them. The leased employees are if you basically put your employees into a PEO, they become the employees of the PEO provider, TriNet, Oasis, whoever. That's all well and good, and a lot of these PEOs have their own EPLI policy, but that policy is really designed to protect the PEO, not necessarily to extend a great amount of protection to the insured organization. It will cover your heirs, estate, legal representatives in case you become incapacitated as an individual, and it will also cover your spouses. In the state of California and many other states, they'll name the spouse in addition to an individual, the president and his or her wife. Why do they do this? Because of community property. That's part of it. Most cases never get that far, but if they do name the spouse, the policy will defend the spouse as long as he or she had nothing to do with the actual transgression alleged. And they'll provide a defense, and it protects all the assets of the individual. What they're really trying to do is force some early settlements at a higher rate. Why? I can't imagine a worse night than going home, and my wife is waiting for me, having got home from work earlier than I, and she's holding basically she's been served a lawsuit because of something I did at my work, and she had nothing to do. I'm almost guaranteed to be sleeping on the couch that night. So they're trying to force an early and expensive settlement. Key exclusions, most of these basically do one of three things. They're either excluding that which is covered in another policy, they're excluding that which is uninsurable according to the law, or that which they just, as reinsurance restrictions or as underwriters, don't want to take on the exposure. For example, workers' compensation. It's covered under the workers' comp, so they're not going to cover it under the EPLI. However, California has Rule 132A, which is a retaliation allegation that's often attached to these when somebody who's been injured or got ill at work layers up. Employment Retirement Income Security Act, ERISA, that's covered under your fiduciary liability. Strikes and lockouts are protections under the National Labor Relations Act. They just don't want to cover that. I'm sure there's some protections out there that we could devise. The WARN Act, Workers' Adjustment, Retraining, and Notification. Some carriers provide coverage for it. Some carriers cover part of it. Some carriers won't at all. Bodily injury, property damage, it's covered by your general liability. But I always try and go back and make sure that if there is an allegation of emotional distress or mental anguish, that is covered under the employment practices. Consolidated Omnibus Budget Reconciliation Act, COBRA. Again, that's a benefit, so that's probably going to be covered under your fiduciary liability. Then the last two are wage and hour claims. Some carriers will provide defense costs. There is, in fact, some coverage available for all of the allegations, including damages, but you got to know where to go to get it. And the conduct exclusions. As I said, that which is not insurable by law. An intentional fraudulent act, personal profit at the expense of the organization. But even under the conduct exclusions, they generally will defend you until such time as the plaintiff proves whatever conduct actually did occur by the individual. Even with those exclusions, almost every one of them will cover some level of retaliation. That is, you fired me because of I filed a workers' comp claim. Therefore, you retaliated against me. They may, in fact, provide some protection for the retaliation. Some policies have what is called the original sin doctrine. In other words, what they're saying is nobody gets covered unless an insured is the one who caused the problem. Many years ago when I was back with Chubb, I was in the home office in a management position. And one of the things that I oversaw was the effective training of trainees. These were young kids coming out of college, excited about their new job. They were flying back to Warren, New Jersey. And we always arranged for a car to pick them up at the airport, take them to their hotel, and allow them not to have to worry about cabs. In one case, this young lady came to me the day after she had arrived and said, when I got in the limousine yesterday and it was taking me, the driver started hitting on me, was saying some lewd, suggestive things. I don't want to complain, but once she makes that complaint, frankly, at that point, I had an obligation to deal with it. But had she filed a suit, that driver is not an employee of Chubb. We might, if there was original sin wording, not have any coverage. Claim reporting, I talked earlier about the claims made wording. Well, when is a claim deemed first made? What I always try and get is limit the number of people who can receive the claim. The CEO, the CFO, head of human resources, general counsel are the only ones, and they have to receive it in writing before it is deemed a claim made. Why? Well, a lot of your organizations may have many offices in many different states and even around the world. And if somebody receives the Mississippi equivalent of a DFEH complaint and they don't know what to do, they just kind of put it aside and don't think about it, policy moves from one policy period to the next, and it's a claims made and reported, all of a sudden we may not get coverage. So we have now controlled the issue. The other thing I always try and make sure is that an oral complaint doesn't work. For example, the young lady who talked to me about the limousine, that's an oral complaint. A lot of times I've seen somebody come in and say, you know what, he said some really nasty things to me, I'm really upset. A few days later, he or she has come back and they're a bit more calm, and they say, you know what, I'm not going to make an issue out of this. You've already made an oral complaint. Once you make that oral complaint, and that is part of a claim, I would be required to have reported it to the carrier. So it can become a lot more onerous. The wage and hour coverage, wage and hour are really revolve around the Fair Labor Standards Act and a number of aspects of it, but you have to make sure that when you are deciding if a person is exempt or non-exempt, you have to make sure that you're doing it right. If they are in fact non-exempt, you have to pay them according to the law. In the state of California, you have to pay overtime for anything over 8 hours in any one day or 40 hours in a week. And a number of times we've all had somebody say, hey, I got to go to the doctor today. Do you mind if I make up my time tomorrow? Oh, sure. You know what? Once they make up that time and they go over 8 hours, you owe them overtime. So you're almost better off saying, you know what, take your time. It goes against your paid time off. Excuse me. But no, you don't get to make up that time. The Immigration Reform Control Act, IRCA, you can get investigative costs for that. Under the current administration, ICE is becoming a lot more aggressive about making sure companies are validating that everybody who is working for them has a right to work for them, is either a U.S. citizen or has a green card. We want to make sure that we're covering that as much as we can. And finally, the Hammer Clause. Hammer Clause is basically a way the carrier can force you to take a settlement opportunity. When are they going to do this? When the demand that they get from the plaintiff is less than the limits. So the first cause of action will demand $5 million. You got $1 million policy, and the plaintiff eventually comes and says, I'll settle this thing for $150,000. The carrier may turn around and say to us, you know, we want you to take this, but inherent in that settlement opportunity might be something that says, and you have to admit that what you did, you did. you may not have done it, you don't want to do it, or quite honestly, admitting might generate a whole lot more other claims. So I always try and at the very least, if I can't get rid of the hammer clause, get a soft hammer. Under a hammer clause, the carrier says, if you don't take the settlement opportunity, we have just capped what we're going to pay because we could have settled it in the absence of your approval. By adjusting and say, unless the reason you don't accept it as the insured has nothing to do with the monetary value. And then secondly, the soft hammer will say, and you will pay a percentage above what you could have otherwise capped the claim at or settled the matter at. So it might be 50 or 75 or even 80%. So at least you have some wiggle room. That kind of gives you the 50,000 view. Probably now, does anybody have any questions about employment practices or why you need it?
If you have any questions, you can type in the chat box at the bottom. While we're waiting for questions, let me just talk about a couple of items. First is we are recording this webinar, and everybody who's on the webinar will get a link to a private YouTube channel where if you want to see it again, it'll have the webinar, and also we'll be sending you a PDF file with all the slides. That's number one. Number two, we're going to have an employee handbook webinar next month. And then right after that, the changes in labor laws for 2018. And then in January, we will probably be having an employee engagement and morale seminar. And those are the next three webinars that are on the horizon. I don't see any questions being typed. So if you have any questions after the meeting, there you go. You can chat with.
There it is.
With Bill. You can send him an email at bill@churchillrisk.com. And if for some reason you don't remember that, just send it to RGEB and we'll forward it to Bill. Having said that and seeing no questions, Bill, I want to thank you very much for the webinar. It was informative. It's a great follow-on to the webinar we had last month about DFEH and EEOC discrimination. And on that note, we'll end the webinar.
Thank you, everybody. I really enjoyed it. Thanks, Barry.